Morning folks, welcome back to the LAB News Studio. Following my plea for content last week, a lot of you said that you wanted to see more news, so here we are. On to the first story for this week then. An unregulated advisor has been held to the same standard as a qualified lawyer in a recent High Court decision in a professional negligence case. Briefly, the facts of this case are Mr. Wright was left with 3 plastic bags inside him following a procedure which took place at an NHS trust in Basildon. He sought professional help in relation to a clinical negligence claim against the trust from firm Troy Lucas, who he believed to be a credible litigation firm. He instructed and retained the services of Mr. George Roos, who, although never claiming to be a qualified solicitor, did say that he was an experienced legal professional. He pursued the claim in an extremely disorderly fashion. According to Mr. Wright's counsel, he made a number of spurious applications for disclosure to the NHS Trust, and he also failed to comply with a number of court orders. He also didn't instruct the proper expert and made fantastical claims for sums of damages in the regions of 1 million and 3 million with no expert evidence to back it up. What transpired was, at the end of the clinical negligence claim, Mr. Wright was ordered £20,000 worth of compensation, but also lumped with a £75,000 cost bill for the NHS Trust costs involved in defending the claim because of the extremely poor conduct of Mr. Roos. Mr. Wright then sought professional advice in relation to a professional negligence claim and instructed and retained Lee Day, who pursued a claim for professional negligence against Mr. Roos and Troy Lucas. The upshot of the professional negligence investigation is that the court ruled that Mr. Roos and Troy Lucas were professionally negligent in the advice that they provided to Mr. Roos, and they were lumped with an order for £263,000 worth of damages plus £73,000 worth of costs, which should have been provided to Mr. Wright had he been properly advised. But what's really interesting about this case is that the court have ruled that where you hold yourself out to a standard of a qualified lawyer, that you will be held and measured against that standard, even if you are actually not one in reality. The reason that I've highlighted this particular case is, one, because it's been very prominent in the news over the last couple of weeks, but secondly because I talk a lot about innovation and the broadening out of the marketplace and the number of different ways in which consumers can now obtain their services and who can provide those services, both unregulated and regulated providers. And I've always been very pro that, and I'm still very pro that broadening of the marketplace, but you should always look at some of the flip sides of the argument to have a balanced view, both in life and also for the purposes of written answers, which are coming up increasingly in training contract applications. So this is one of the downsides of that broadening of the marketplace, is that there's a lack of clarity for consumers as to who is actually a qualified lawyer and who is a legal professional who could have very limited experience. But it's encouraging the courts are ruling that if you hold yourself out to stand of a qualified lawyer, you have to be measured against one, because that gives slightly more protection to consumers. But nevertheless, it is a factor to consider when you are talking about the changing marketplace. Next, on to some more regulatory matters. A solicitor emailed a client his own bank details rather than the firm's bank details and claimed this was a pure accident by force of habit. Convenient. Needless to say, the SRA did not buy it, sent him to tribunal, and wham, struck off. Mr. Akin-Close was practicing at the associate law firm in Newcastle when he channeled 4 payments coming to £2,700 into his own account rather than the firm's. He denied knowingly or deliberately retaining the funds and claimed that he did not regularly check his online bank account, so he wasn't aware of what had happened. Moral of this story, don't mess with client money. Top 50 firm Ince & Co has gone into administration and it's been acquired by Gordon Dadds. Ince & Co is famous for its shipping and insurance type work. So if you were planning on applying to Ince & Co, be aware that it's now Ince Gordon Dadds, and they're in a little bit of trouble financially. Next, The Lawyer magazine has published statistics for NQ and trainee salaries both inside and outside of London in 2 very helpful tables. I will link the article in the description below. I can confirm that the highest NQ salary in London is a whopping £143,000, and that's shared by the likes of Kirkland Ellis, Latham Watkins, Aiken Gump and Millbank Tweed, whereas towards the lower end, skulking around the £40,000 to £50,000 NQ salary mark, are the likes of BLM, Stewart's Law, Hamlins, and some are even lower than that. So if you're interested in NQ and trainee salaries, head to the link in the description. Next, a survey of the top law firms has revealed that only Irwin Mitchell and Shoesmiths have reached the target 30% of women in partnership positions. wins. This is very encouraging for Erwin Mitchell and Shoesmith, but slightly concerning for the rest of them, who are considerably behind. I will link all the details and stats in the description below, but if you are a female looking to make it all the way to the top, then you will be in good company at either Shoesmith or Erwin Mitchell. Right guys, that is it because it's getting way too dark outside. I hope you've enjoyed this. If you do like to keep up to date with the news as it happens, then please follow me on Twitter. I also tend to give a much more detailed analysis on my LinkedIn feed, and all the juicy stuff is on Instagram. I will be back next week. For any of you who are coming to the Legal Cheek Secrets to Success event on Wednesday, I will see you there. Take care guys.